Did you know you could pass the real estate exam for national or Texas by practicing the following questions? So I'm reviewing some national questions, and at the end, I'm going to be doing some Texas state questions for those reviewing for only the Texas exam. The national portion of this seminar or webinar, I should say, of this session covers all 50 states. So please stay on here for reviewing national questions, and then you may leave if you're in another state. And at the end, we will do Texas state questions. This is Lillie Hendy Dominguez coming to you from San Antonio, Texas with YouTube AgentPrep. I am an active realtor practicing real estate in San Antonio, Texas, and in the Rio Grande Valley. So let's get with it. I'm going to share with you the book that we're using. So this is the book that we use, Texas Real Estate License Exam Prep with, it's 2024, it was published. So it's prepared for the 25 sessions with all the lawsuits and changes that came about and new Texas laws or changes also for national. I have permission to use this book, so there is no copyright done. Okay, we're going to continue from last week. And so we're going to start out with national practice test, and starting out on page 238 with question 26. So I give you an opportunity to answer the questions while you're attending. So you may type your answer on the chat, type the question number and the letter answer. And that way, if for some reason it is wrong, I'll review it and give you more information on it to understand it. All right, so and this section is, so this is rights, interest, and estate ownership, okay? Test 1, rights, interest, and estate ownership from the book that I just showed. Number 26. So an estate at will, what is that? A, cannot be terminated. B, is terminated only if so stated in the lessee's last will and testament. C, terminates on the death of lessor or lessee. D, terminates on the date specified in the lease agreement. So which is the correct answer? Type it in the chat. And I will let you know what the answer is in a short moment. Remember to type the question number and the letter answer. I just put it on. Let me, I will mute that. So I'm watching it in case something goes wrong. I know. Okay, so the answer here is C. An estate at will, C, terminates on the death of a lesser or lessee, because it's an estate that was allowed to be used by someone until they were living, until the estate owner is alive. So here are things to learn for vocabulary: estate, at will, testament, lessor, lessee, and specified in the lease agreement. Know those vocabulary. Number 27. A tenant continues to occupy an apartment after lease expiration without the consent of the landlord. This type of estate is called what? So this is dealing with rentals. A, an estate at sufferance. B, a holdover estate. C, a canceled leasehold. Or D, a hostile leasehold. So when a tenant continues to occupy it, you could call them a squatter, right? But they did have a lease agreement or some type of an agreement. They continue on after it expires. What is the seller or the owner having to deal with? in this situation? So the answer here is A. It's an estate at sufferance. And you probably wonder, well, who's suffering? Well, the owner is suffering, right? Because the lease expired and there's a tenant that's there that's not paying. So a tenant occupies the premises without consent of the landlord or other legal agreement with the landlord. Usually, such an estate involves a tenant who fails to vacate at the expiration of the lease, continuing occupancy without any right to do so. For example, a tenant violates the provisions of a lease and is evicted. The tenant protests and refuses to leave despite the eviction order. That can be challenging. So when an eviction is filed, it goes to a small justice of the peace, a small courthouse, and they'll have to send out letters. By an officer will deliver, right, the eviction, but they have to listen to both sides. So it's going to take 1 to 3 months, depending on the location or the state. Every state has their own landlord and tenant laws, and they're online, so they can be researched. If you currently own an apartment, a condo, a home that you are renting, make sure you know the landlord and tenant rights. Tenants are typically protected, so landlords have to follow everything to the T. Number 28, a tenant without a lease has been sending the landlord monthly rent checks. That's good. And the landlord continues to accept the payments. What kind of leasehold estate exists? A, estate for years. B, estate from period to period. C, estate at will. Or D, estate at sufferance. Okay, so it is not estate at sufferance, right? We just discussed that. So the answer here is an estate of period to period. Why? Because it says they're sending landlord monthly rent checks. So it's a month-to-month type of lease. So it could be for a year, but they're staying there month to month, or it could be a day to day, week to week, month to month. That is considered an estate from period to period. (128B). Number 29, a fee or life estate is held by an individual. How many persons? An individual. One. This form of estate is referred to as A or N. A, tenancy in severalty. B, tenancy by the entireties. C, absolute fee simple or legal fee simple. So a fee or life estate is held by an individual. What kind of an estate is that? Keep in mind, there are 4 different types of tenancies. And I won't mention them at the moment until we have the answer. So the answer here is A, tenancy in severalty, because it is one person. Tenancy by the entireties is when you have a married couple and they own the whole property together. So also you can have, so tenancy in severalty can also mean sole ownership, ownership in severalty, estate in severalty. So you may see it in one of those forms in the exam. There's also tenancy in common. So there's 4 different types of tenancies. Make sure you know the difference. Number 30, 6 people have identical rights in a property and enjoy an indivisible interest. What is indivisible? However, any of the owners may sell or transfer his or her interest without consent of the others. This form of ownership is what? Okay, so you have multiple individuals here, 6 of them, that have ownership on a particular property, indivisible interest. So the answer, the type of ownership, would it be A, joint tenancy, B, homestead ownership, C, tenancy in common, or D, estate in severalty. So the thing to pay attention to here is that it says, however, any of the owners may sell, okay, may sell or transfer his or her interest without consent of the others. That is a clue as to what the answer is. What type of ownership? So the answer here is tenancy in common, which is C, because they have something in common. They have ownership of the property in common, and either one of them can sell it without the approval of the others. There is no restriction. If it was joint tenancy A, then each partner, if one of them dies, their ownership goes to the other two. If one of them wants to sell, they have to offer it to the other two members, and all three have to agree because they have the first right of refusal in order to purchase it because they bought it together at the same time, same date, and same percentage. So in a joint tenancy, they can have equal percentage ownership. It can vary, but they have a tight agreement. Number 31, the 4 unities required to create a joint tenancy include which of the following conditions? We were just talking about that. So A, parties must acquire respective interests at the same time. B, parties must be residents at the same state and at the time of acquiring the interest. C, parties must be family members. Or D, parties must have joint financial responsibility. So which of the, under the 4 unities that are part of joint tenancy, which of the following conditions is part of that? So I mentioned one earlier. And so the letter here, answer is 31B. Parties must be residents of the same state at the time of acquiring the interest. No, I'm sorry. Pardon me. I was thinking they had to acquire it at the same time. However, parties must acquire respective interest at the same time. It's A. So it is at the same time. They don't have to be in the same state. They just have to acquire it at the same time, same day, same location, and have a particular division of it, and it's indivisible ownership. They all have the ownership of the property, not just 33, 33, 33, or 25 times 4. Okay, so here it says to create a joint tenancy, all owners must acquire the property at the same time, use the same deed, acquire equal interest, and share in equal rights of possession. This is referred to all the 4 unities. So acquire the property at the same time, use the same deed, have equal interest, and share equal rights of possession. So they don't own just their rights of only a quarter of it, if that's what they bought, if there were 4 of them. Right, number 32. Unlike tenants in common, joint tenants have what? A, own distinct portions of the physical property. B, cannot will their interest to a party outside the tenancy. C, may own unequal shares of the property. Or D, cannot encumber their interest to outside parties. Okay, so what's the difference between tenants in common and joint tenancy? What is the main distinction of those 2 types of ownerships? So the answer here is B. They cannot will their interest to a party outside of the tenancy because they are now joint tenants. in the deed, in the will, and they can own a different percentage. Okay, however, they cannot will their interest to a party outside of the tenancy. So the survivorship feature here on, we're on number 32. On the difference in tenancy and commons is the survivorship feature of joint tenancy presents an advantage of tenancy in common in that interest passed without probate. Internet issues. On the other hand, let's see here. Oops. On the other hand, joint tenants relinquish any ability to will their interest to parties outside of the tenancy. So that's what I mentioned earlier, that joint tenants, should one of them die or one of them sell, it goes to one of the other tenants in common, the other joint tenants that bought it at the same time, deeded at the same time, have full possession and equal ownership, share in equal rights. So the main difference here was B. They cannot will their interest because that's part of joint tenants, but not tenants in common. Number 33. Which of the following life estates is created by operation of law rather than by the owner? A life estate. A, conventional life estate. B, ordinary life estate. C, legal life estate. Or D, community property life estate. So this is a life estate. It says here it's created by operation of law. So think of the word of law. What could that direct you to think that it was or that it is? So the answer here is a legal life estate. So that life estate created by operation of law is called a legal life estate. So 133 is C. So a legal life estate is created by state law and opposed to being created by property owner agreements. The focus of a legal life estate is defining and protecting the property rights of surviving family members upon the death of a husband or a wife. So every state has different laws when it comes to ownership of property. Some may be similar. However, that's why we have a state exam, and then we have national. Some states combine both the national and Texas questions in one exam. Here in Texas, we use two separate exams. $34. Dang here. Okay, bear with me. Sometimes I figure this out quickly and other times I do not. Okay, number 34. Which of the following is true of a homestead? So what is a homestead? Definitions here, vocabulary. A homestead interest cannot be conveyed by one spouse. B, a homestead interest cannot be passed to the children of the head of household. C, homestead interest is a form of conventional life estate. Or D, homestead is a primary or secondary residence occupied by a family. So which is it? Which is a homestead? So the answer here is A. A homestead interest cannot be conveyed by one spouse. Both spouses have to agree to a sale of a property or giving it to someone else, because a homestead, a property was purchased together if they're married at the same time. So it belongs to both in equal interest, and that is their primary residence. So it is a homestead. And creditors like credit card companies or something like that, cannot put a lien on the property. A lender, yes, because they have provided a loan for that property. So a lender can't put a lien on a homestead property when there is an existing loan. But creditors like credit card companies cannot. Number 35, a tenant in common, one of the interests without the consent of the other tenants in common. B, use his or her interest in a estate to encumber the entire estate. C, sell, encumber, or transfer his or her interest only to the other tenants in common. Or D, sell, encumber, or transfer his or her interest only with the consent of all the other tenants in common. So what is the answer here for number 35? The answer is A. So a tenant in common can A, sell or transfer his or her interest without the consent of the other tenants in common. So these are different individuals that are not married. Okay. If they were married, it'd be tenants by the entirety. When they're not married, then it's tenants in common. It can be 2 individuals, 3, 4, and they could each have a different percentage of ownership. However, they have the equal possession and use of the property. Number 36. Which of the following would be considered community property? What is community property? A, property acquired before marriage. B, a motorcycle bought after the marriage with separate property funds. C, income derived from community property. Or D, a mother's heirloom wedding ring gifted to the wife after her wedding. What is community property and when does that take place? So the answer here is C, and I'll explain why. So C is community property is income derived from community property. So let's take, for example, one of the spouses could have owned the property prior to marriage. However, while married, they earn income because it is a rental. Any income that comes in during the marriage is considered community property, not necessarily the real estate. Any improvements that are made on it is community property during while they're married. Now, if one of them had it in a LLC, then or corporation, then it belongs to the LLC or the corporation. Number 37. No, that didn't work. It's not. Okay, internet issues. Okay, we're back. Number 37. When real property is held in a land trust, what kind of trust? A land trust. Who controls the property? A, the trustor. B, the trustee. C, the beneficiary. Or D, the mortgagee. So it's asking here about a land trust. Whenever there's a trust, you must know how many parties are in the trust. So, because there's different parties in a trust. So who controls the property? Who is the actual owner of the property when there is a land trust? So the owner is C, the beneficiary. That's the actual person that will control, that controls the trust. An owner has bought a piece of land or a property, put it in a land trust, and there has to be a trustor, a trustee, and a beneficiary. And the beneficiary can be whoever the trustor wants to own it after them. It could be the trustor. The trustee is the one that manages the property and takes instructions from the owner and to whatever they want to do with the property, get a loan on it or sell it. So the trustee signs for the owner. So there's a trustor, a trustee, and a beneficiary. And each one of those is different. So the land trust allows the trustor, who is the owner, to convey the fee estate to the trustee and to name himself or herself as the beneficiary. The land trust applies only to real property, not to personal property. The agreement or deed in trust grants the beneficiary the rights to possess the use of the property and to exercise control over the actions of the trustee. And sometimes a trustee could be an LLC. I'm sorry, the beneficiary could be an LLC, or the trustor could be an LLC and the beneficiary is the actual owner. And that is when individuals own multiple properties, they want to have multiple levels of asset protection to avoid being sued by a tenant or someone else that they maybe sold it to. So the investors don't want to own anything. Their LLCs do, or their corporations do. And the trustees manage it, but they are essentially the beneficiary, the owners. All right, number 38. In a community property state, so what kind of state? Community property state. John marries Patricia. Prior to the marriage, John owned an SUV. During the marriage, John bought a Buick. John and Patricia bought a second property with money earned from Patricia's job. And each individual received a motorcycle from Patricia's uncle as a gift. What property is considered community property in this marriage? So remember, what is community property in a community property state? So A, the SUV, the Buick, and the second property. B, the SUV, the Buick, the second property, and the motorcycle. C, the Buick and the second property. Or D, the Buick, the second property, and the motorcycles. So remember, community property is that John marries Patricia. Prior to marriage, John owned an SUV. So it wouldn't include the SUV. So A and B would not be correct. You could eliminate those right away. So then it comes down to John bought a Buick. And during the marriage, John and Patricia bought a second property with money earned from her job. Well, that's income coming in during the marriage, right? So the answer here is C, the Buick and the second property, because these were bought during the marriage. The motorcycles were a gift, so they do not apply as community property. So learn, because since we're doing national questions right now, there are community property states, and they are different from other states. Okay, 138C. Oh, come on, computer. All right, number 39. Which of the following is true of a cooperative? What is a cooperative? Vocabulary. A cooperative may hold an owner liable for the unpaid operating expenses of other tenants. B, the owners have a fee simple interest in the airspace. The airspace is space above the property, or their of their respective apartments. C, owners may sublease their apartments even if they sell their stock in the cooperative. D, the proprietary lease is guaranteed to have a fixed rate of rent over the life of the lease terms. So what is true about a cooperative? We have communities like a homeowners association or community. Then there's other types of ownership, cooperatives. There's, excuse me, different types of ownership. The answer here is A. A cooperative may hold an owner liable for the unpaid operating expenses of other tenants. So they are members of a cooperation, a cooperative of units. So let's see what it says here. A cooperative, since a corporation owns an undivided interest in the cooperative property, debts and financial obligations apply to the property as a whole, not to individual units as in a condominium. Okay, as I mentioned, this is owned by a corporation and not like a condominium where the individual owns the whole condominium, but there are common areas and there are homeowner association dues. They take care of the roads, they take care of the outside. And here, it's a corporation owns an undivided interest, right, equal to everybody in a cooperative property. So different people get to use the property. So corporations, business corporations and large companies probably have that. Debt and financial obligations, again, apply to the property as a whole, not to the individual unit, as in the condominium. So did I type it? No. 139C. Oh, I better make sure I type the right answer. The answer is A. Okay, did that go through? Yes. All right, number 40. Oops. Tenancy in common. A, the co-owners must be related. B, the owners enjoy an indivisible interest. C, the tenants must acquire their interest at the same time. Or D, the tenants must pay equal amounts for their interest in the estate. So what is a tenancy in common? Which of the following statements is true? So are the owners related? Do they own an indivisible interest? Must they acquire their interest at the same time? Or the tenants must pay equal amounts for their interest? Tenancy in common, one of the four types of ownerships. So the answer here is 1B, 140B. The owners enjoy an indivisible interest, meaning they own the whole property, not just the percentage that they bought. So, and they don't have to be related. The tenants must not have to acquire it at the same time. And the tenants must not have to pay equal amounts for their interest in the estate, because they may have different interests. One might own 25%, the other 75, 50, 50, 30, 30, 70, 40, 40, 20. So those are the different amounts of interest that they have. So they pay for their particular portion in a residence and whatever they own. All right, so those we just did, I think 25 questions. Let's see. Yes, we just did 25 questions in the national exam. The national exam of this book. So we're going to move into Texas state questions. in just a moment as soon as I get set up here. Let me get set up for a moment here. All right, and we will start. Oh, I just forgot which question number we're starting at. Oh, well, I can look at, bear with me. So for the Texas state, we're doing test number 12, and we're starting with, yes, with number 1. Okay. Test number 12. And I'll show you what that test deals with. So test number 12, this is on Texas, deals with Texas licensing and regulation. So put your thinking cap for Texas state questions. Texas regulation. Or Texas licensing regulation, not and regulation. Oop. So this is test number 12. So if you were here from national, you may now leave because we're now practicing only Texas questions. All right, number 1. Which of the following best defines a broker? A broker in Texas. A Texas resident who performs brokerage activities for compensation. B, a licensee who sells his or her own property. C, a person who performs brokerage activities for others for compensation. Or D, a residential licensee who manages salespeople. So what is the answer here? So 12-1, what is the answer here? What does a broker do? So a broker is C. A broker is a person who performs brokerage activities for others for compensation. Some states call a broker a principal broker. In Texas, it's a broker, and we're salespeople, sales agents, we're realtors. So a broker is a party engaged in specializing specifically identified brokerage activities for others for compensation, right? Because we're getting paid commission. So we're doing business with others, sellers or buyers or tenants or lessors. It must be for other parties and it must involve compensation, but a broker does not have to be licensed to be defined as a broker. Well, that's interesting. It must be for other parties and it must involve a compensation, but a broker does not have to be licensed to be defined as a broker. Oh, okay. So I guess a broker can sometimes be someone who manages the other realtors, but they cannot actually do business with clients. They're just managing other realtors. All right, number 2. Sorry about that. Number 2, which of the following best defines a designated broker? A, an active Texas broker designated by a licensed business entity to act on its behalf. B, a non-officer of a licensed corporation named to conduct real estate activities on its behalf. D, a dual agent in a brokerage. D, a licensee who has successfully passed his or her required realtor designation curriculum. So, which of the following best defines a designated broker? A designated broker is A, an active Texas broker designated by a licensed entity, business entity to act on its behalf. So it could be a brokerage, it could be a company, and they are the main person, individual responsible for their realtors. So 12-2A. So let's see what the answer here says. So the answer says designated brokers are active licensees working as an officer or partner in licensed business entities who have been designated to act on the organization's behalf. The following parties does have to have a license to operate legally. A person who shows his licensed brother's listing to neighbors in the immediate neighborhood. B, MLS services who provide filing listing services but do not get paid for resulting transactions. C, a family member who sells a house she just inherited from her father. Or D, an employee of Burger King who assists in the purchase of a site for his company. So which one does not have to have, or I'm sorry, which party does have to have a license to operate legally? So number 3 is a person who shows his licensed brother's listings to neighbors in the immediate neighborhood. So that licensed realtor, that licensed individual is showing listings, whether it belongs to a family member or not. So that requires a license legally, and they can do it. MLS services who provide listing services, that's like the multiple listing service. No, they don't need to have a license to operate because they work for a multiple listing service. A family member who sells a house or just it from her father, no, they can be a for sale by owner. An employee of Burger King, their company, they can be the managing person within their corporation, and they're designated to be able to purchase land or purchase sites. Number 4. All of the following are exempt from real estate licensure except exempt. A Texas attorney. B, a party acting under the auspices of the court. C, an on-site manager of an apartment complex. Or D, a city manager who operates a rental property. So all of the following are exempt from real estate licensure except one. Which one is not exempt? The answer here is D, 12-4D. The city mayor who operates a rental property. Okay, they don't need a real estate license in order to rent their own property. Individual owners can do that. So let's see, all of the following are exempt from real estate licensure except one. Oh, I'm sorry. I take it back. A city manager, the answer is correct. A city manager who operates a rental agency. So they do have to be licensed because they're like a property manager. It says a rental agency. So the answer here says a Texas attorney, court assignee acting in official capacity, and on-site property manager are all exempt from licensure. A mayor who also operates a rental agency is nevertheless required to be licensed. Why? Because he's operating a rental agency. An on-site manager is the manager of an apartment complex, so they're exempt. Okay, the party acting under the court, as they are the what do you call it, executor, okay, or the administrator, they don't need it because they're assigned by the court. A Texas attorney, they don't need it. They know Texas law, but they're not representing somebody else in a piece of real estate. If they do expect to get money as commission, then a Texas attorney would also need a license. Number 25. William has been named designated broker for the partnership he works with. For this to be acceptable, William must do what? A, be an actively licensed sales agent or broker. B, be a general partner of the firm. C, be an employee of the partnership. Or D, must have been affiliated with the firm with a minimum period of 12 months. Okay, so this William is a designated broker for the partnership he works with. For this to be acceptable, William must have what? A, B, or C? So since he's a designated broker for a partnership, he has to be a B, a general partner of the firm. That was 12.5B. Okay. The next one doesn't have a number, but it's 12.6. 12.6. If an applicant fails to prove to the commission that he or she blank, he or she can be denied a license. A, is a registered to vote. B, has a net worth of over 25,000. C, is honest or trustworthy. Or D, has an insured car and driver's license. What must we as licensees or individuals wanting to get a license have to prove to the commission? In this case, Texas Real Estate Commission. Anybody getting a license in Texas is licensed by Texas Real Estate Commission. So real important here is being honest or trustworthy. Interesting, the answer has it as B, but we must be honest or trustworthy. 12.6, right? Okay, the book selected the wrong letter answer, but stated the correct words. So honest or trustworthy. So an applicant who fails to satisfy the commission as an individual applicant's honesty, trustworthiness, or integrity can be denied a license. Because we're dealing with individuals, homeowners, home buyers, and we must practice honestly, be trustworthy, and with integrity. Okay, number 7. Number 7, license. Okay, we just got an interference here. To obtain a Texas real estate sales agent license, applicants must complete what? A 60 hours of real estate principal and 120 hours of finance law, contract forms, and agency. B, 90 hours of real estate principles and 90 hours of law, finance, and agency. C, 120 hours of pre-license education and 60 hours of post-license education during the 2-year initial license period. Or D, 90 hours of pre-license education and 90 hours of post-license education during the 2-year initial license period. So if you're getting ready to take this exam or you are studying for it, you know how many courses you're having to take, right? So this should be a quick answer. We have 2 courses of real estate principles, principles 1, principles 2, and then 30 hours of each of the following: finance, law, contract forms, and agency. So that's comes to 180 hours, which is 6 courses. So letter A. Following is true regarding license requirements. You can look these up under the Texas Real Estate Commission website. A, non-resident licensed applicants must meet special out-of-state education requirements in Texas law. B, non-resident applicants must agree to forfeit any non-Texas real estate license. C, not successful license applicants will be issued an active license, which is sent to the applicant sponsoring broker. Or D, applicants who have met all requirements will receive an inactive license. So which of the following is a true statement that's required by TREC for a license for license requirements? The answer here is D. Applicants who have met all requirements will receive an active license. And that includes the 6 courses plus taking the exam, plus getting your fingerprints and getting a background check. All those have to be approved by the Texas Real Estate Commission, and therefore the license goes in inactive. Now, it's C. You would think that C is also correct, right? Because it's a successful license, applicants will be issued an active license, which is sent to the applicant's sponsoring broker. However, it just says successful license applicants. It doesn't say that they've met all the requirements. Okay, why is this not moving forward? Number 9. Which of the following is true regarding the education requirements for the broker's license? A, applicants must complete 630 hours of post-secondary education. B, applicants must complete 900 hours of post-secondary education, including 630 hours of core real estate courses and their approved equivalent. C, or their approved equivalent. C, applicants with a bachelor's degree or more are deemed exempt from the core 270-hour requirement. Or D, applicants must complete 270 hours of post-secondary education. So it's required for us to take lots and lots of hours. And you must know here how many hours you're allowed if you have a bachelor's degree, because you can be given a certain number of hours for having a bachelor's degree that Texas Real Estate Commission, known as TREC, accepts, which they did in my case. Okay, the answer here is letter B. Applicants must complete 900 hours of post-secondary education, including 630 hours of core real estate courses or their approved equivalent. So the 630 hours could be in place of the bachelor's degree. So if an individual has a bachelor's degree that is acceptable to TREC, then it qualifies for 630 hours that they will not have to take. That was 12.9B. Yeah, that was okay. Got that. Number 10. TREC, Texas Real Estate Commission, may waive a broker's education and experience requirements if A, the applicant earned a master's degree in real estate. B, the applicant was a licensed attorney for 2 of the prior 4 years. C, the applicant was a broker for the prior 2 years, completed the CE requirements, and was active for 2 of the prior 4 years. Or D, the applicant was an active sales agent for 4 of the previous 5 years preceding the application. Type your answer in the chat. The answer here is C. The applicant was a broker for the prior 2 years, completed the CE requirements, and was active for 2 of the 4 previous years, 4 prior years. So TREC may waive a broker's education. So it wasn't a sales agent education, it was a broker, and experience requirements if the applicant was a broker for the prior 2 years, completed the continuing education requirements, and was active for 2 of the prior 4 years. Oh, we're doing number 11. Number 11, which of the following statements must be renewed every 3 years? B, all licenses requires on October 3rd, expire on October 31st or even years. C, TREC distributes a notice to renew 3 months prior to expiration. Or D, timely application must be received no later than 30 days following expiration. So which of those is a true statement? So the answer here is C. TREC distributes a notice to renew 3 months prior to expiration. So we receive an email and a letter in the mail. 3 months prior to the expiration. And even then, sometimes we fail to get our licensed courses, renewal courses done on time. It's only happened once to it twice, maybe twice. Number 12, and that's okay. As long as we pay the renewal fee and a late fee, then we're given another, I think, 90 days to complete the remaining courses. I'm trying to think, 90 days or 60 days. Okay, I lost my track. I have to renew mine. I'll be doing it before the expiration date. Okay, 12, a licensee misses the deadline for license renewal. In this case, the licensee A must retake the license examinations, pay the late fees. B, must pay a deferral fee and complete any CE requirements within 60 days. C, must go inactive for a minimum of 90 days. Or D, must resubmit an initial licensee application, including background checks. Nah. Okay, so this is the one that I was talking about, and it refreshed my memory. So the answer here is B. If a licensee misses the deadline for license renewal, in this case, must pay a deferral fee, okay, which I think it's 200, and complete any CE requirements within 60 days. And the CE requirements are 18 hours here in Texas. Did I say 18 hours or 16? It's 18 hours. And we have to do legal update 1 and legal update 2. Each of those is 4 hours. And then the rest can be any other course that we'd like. Electives. Number 12, 13. Which of the following is true regarding the renewal of an expired license? A, renewing applicants do not lose active status if they properly renew within 90 days. B, with a proper application, late renewals filing within 60 days of expiration will not lose active status if sponsored throughout period between expiration date and new license issuance. C, expired licensees automatically become expired, inactive. D, the license period for the renewed license begins the day the late renewal application was received. So which is correct on number 13? When a license, when the renewal of an expired license. The answer here is B. With a proper application, late renewals filing within 60 days of expiration will not lose active status if sponsored throughout the period between expiration and new license issuance. So that was similar to the prior question, right? You can, your license can come to an expiration date, but we must pay a deferral fee and complete the 18-hour CE requirements. That can sometimes change. Right now it's 18 within 60 days. So which is true regarding renewal of an expired license. 60 days of expiration. Okay, 60 days. So we want to do it prior to expiration and give it a few days, not the day of or the day before. Okay, so 1214 was B, is B. Oh, darn it. Which question were we at? Sorry. We did 12, 13. I just typed the answer for 14 and that's incorrect. So let me see. Can I remove it? Yes. Because we haven't done number 14. So I just removed it. Okay, number 14. I will do something different here. Number 14. Licenses can become inactive for many reasons. 3, okay, does not trigger an inactive license. A, the state changes the education requirements for licensees. B, the sponsoring broker moves to a different state. C, the brokerage goes bankrupt. Or D, the licensee applies for inactive status. So which statement does not trigger an inactive license for number 14? The answer here is A. The state changes education requirements for licensees. If the state changes the requirements at the time that we're renewing our license, then we still have an active license. It does not trigger an inactive license. Hmm. Number 15, which of the following are causes for the deactivation of a licensed entity license? I'm sorry. Business obtains E&O insurance. B, the entity elects to deactivate. C, the entity fails to complete a transaction in a 12-month period. Or D, the designated broker is promoted to president of the corporation. So which one would cause a business entity license to go inactive? In this case, it would only be if the entity elects to deactivate, which is B. Any questions before we depart? If not, so today we reviewed So today we reviewed 25 national questions from the new book. And let me show you the new book. And this book is published for different states, the majority. And computer working slow. So it's the blue book that you see here. It's in many different states. Okay, so for some reason, computer is working slowly. Okay, so it's the blue book, Texas Real Estate License Exam Prep. And each of these books has national questions. So any book that you buy is going to have the same national questions or all in one exam. In Texas, we have a national portion that we must pass separately from a Texas exam that we must pass. If we pass one, we don't have to repeat that. We only repeat the one that we failed. So the one that we didn't succeed in. So this is the book we used today, and we reviewed 25 national questions. And then the national questions were rights, interest. Oh, I took my screen off. So the national questions today were on test 1, rights, interest, and estate ownership is what we continued. And then the state questions, we started with, test number 12, Texas license regulations. So if you have any questions on what we just reviewed, hey, please type something in the chat or type a comment on the YouTube video after you have access to it. You'll have access to it shortly afterwards. And if not, hey, I hope you enjoyed the review of these 25 questions and 15 Texas state questions. And stay tuned for future videos. I've been doing this on YouTube since 2020 and have been tutoring in person or on Facebook since 2014. So I've been doing this a while, and I have to stay up with Texas state laws and anything new that changes nationally. So just know that I am practicing real estate, and so you are preparing for your exam, and I had other people help me and recommend books for me to use, which I purchased. And there's a lot of free material online that you can study and ask ChatGPT or buy those books. Other books have vocabulary. This particular does not have vocabulary. There's an old book that is the Texas Real Estate License Exam 4th edition. I might mention it on the description. That is an excellent section. However, you can just Google real estate exams. You can also go to Prep Agent with Joe Juder. He does a lot of videos on vocabulary. And I also, in one of the lists in here, have a lot of vocabulary. So I did put in the playlist in the description of different playlists that you can review of older videos. So thank you very much for attending, and until next time. This is Wow Lillie Handy coming to YouTube and staying good luck with